Upson. May it please the court, counsel Keith Upson for defendant appellant Oscar Crespo Rodriguez. I'd like to reserve 2 minutes for rebuttal, if I may. If someone did not know what a laser sight was before they read this trial transcript, they still wouldn't know after they read it. And what's significant about that statement is it drives home the fact that the state didn't introduce any evidence regarding laser sights.
There was testimony
about
laser sights, and the rebuttal involved a comment by trial counsel saying they had all these technological things available to them and they chose to not use any of them. Why isn't that opening the door as a fair comment and rebuttal?
Which essentially, Judge, in 2 sentences or 1, covers the crux and the core of our first issue on appeal, and is nonetheless still error requiring reversal.
I looked at the video, and one of the stills did appear to have a dot there, and that was presented to the jury, and the jury was able to accept or reject that, wasn't it?
Judge, at the risk of not directly responding to the question, you just covered the entire trial and the issues start to finish. And if I could back up to the testimonial portion, which was the first that you said, there were maybe 2 paragraphs in which that witness said laser sight. If the court recalls, that occurred during rebuttal questioning.
And if I recall, and correct me if I'm wrong, it didn't. The testimony didn't relate directly to, do you see any evidence of a laser sight in this video?
It did not,
Just
Judge.
are you familiar with laser sights?
It did not, and at no point at any time throughout the state's case did anyone do that. Did anyone even say, oh, sometimes even in low-quality, grainy, nighttime security vision, you will see such an appearance. Not one word until, and I'm cutting all the way to the end, even though there's some ground I have to cover in your question in between, until rebuttal argument.
Well, you know, the interesting thing, Mr. Upson, and this sort of cuts 2 ways, I guess, on your argument, is I looked at the videos first. I don't know why. I guess it just being the age in which we live. I didn't notice there are 2 red dots in Exhibit 9. I didn't notice them. Then I read the briefs. I go back and I look. Then I notice the dots. But when I'm looking at the video, I mean, it looks like the defendant. The video shows the defendant putting hand to the torso of the deceased and running away, and then the deceased. It looked like that's when the deceased became injured. Frankly.
And Judge, I appreciate that was the state's argument.
Oh, yeah, right. So the question, I guess, is, assume that it was error, how harmful do you think it really was?
Oh, Judge.
Because, I mean,
I'm so grateful on the panel you asked that question.
I always try to help you out, Mr. Upson.
And I appreciate it because you know I'm going to talk about the fact that you wrote Robinson.
And I'll tell you what. I've been doing this 22 years now. The thing that I always hate when I'm in OA, I don't hate you, is when they say, as Judge Northcutt wrote, and I go, oh God, what's coming now? You know.
And the reason why I would suspect, aside from the fact it's cited in the initial brief and relied on in the initial brief, obviously, is you probably forget a lot of them. But it was significant enough to you that in the first paragraph you referred to No Job Bob. And I don't know that nicknames like No Job Bob have come across your desk, and how many times in those 22 years. Yeah. And it was significant enough to you or the drafter of that brief that you ultimately adopted. But the facts in that case, where you discussed it in the final paragraph, there were multiple counts, but the one at issue was the burglary count, whether or not he was an invitee or not. And this court acknowledged in the final paragraphs of Robinson that even where evidence had been admitted that on his return to the dwelling, he kicked the door in, that still wasn't enough to overcome the presumption of harm from the prosecutor's statements in that case, mischaracterizing testimony that he had been abusive, get out, you're unwelcome, which apparently, not having the benefit of having read it, but only this court's decision, apparently was a fabrication by the state. In that case, as in here, defense counsel objected. In that case, unlike here, defense counsel asked for an opportunity to rebut the rebuttal argument, which was overkill, but which the court, having denied the objection, having overruled counsel's objection as occurred here, it was done, it was preserved. Because when you argue stuff like that for the first time in rebuttal, that's it. There's no opportunity. There is no last word. When you ask the witness on the stand in redirect about lasers without tying it to anyone or anything, and again, I contend in the brief as well, that might have been multiple experts that were required. I think
Clearly, the question, it reads like the question was asked to set up the argument. The question was not asked in the context, do you see in the video or this still?
And what would it look like? And how do they operate? Are they battery powered? How are they, what turns them on? Is there a standard? Are they all different kinds? And what may be more telling is her testimony that the only kind she'd ever seen or the only kind she'd ever encountered were red, which a Google degree can quickly refute that perhaps that witness hadn't seen a whole lot. Now, counsel did not object at that point, and he didn't ask for an opportunity to recross on that point and get into that.
So if we were to go through the harmless error analysis then, I would wonder whether or not that statement in rebuttal, where does that sit in light of the theory of case was it wasn't me that shot him, and it was the instigator, and pardon me, Riviera that shot him. He was the instigator, but we had testimony that was presented to the jury that Riviera did not have a firearm, and that the only person that was able to jive what the coroner had testified to, that it was basically a muzzle to the body inflicted gunshot wound that was close enough to do such, was Mr. Rodriguez.
Well, and Judge, and I haven't gone back to address all the questions you asked in that compact sentence or two, not the least of which is how is that not invited on rebuttal? But to fully discuss harmfulness, we have to look at the totality of the state's case. We have to look at everything here. And for whatever reason, the state chose their theme to be process of elimination by showing you who couldn't have done it. We're going to show you who did.
Well, I think that was probably in conform with their best evidence, which was the medical examiner.
Well, I also think, Judge, that at its very worst, excuse me, which is no concession, but that its very worst, the facts here may have supported manslaughter with a firearm. But I think in another example of prosecutorial greed, they went one step further. As an aside, I don't think second-degree murder, I don't think process of elimination in the state of Florida can ever support second-degree murder. And wouldn't it be great if there'd been a motion for judgment of acquittal so I could have briefed that issue and argued that issue?
And so that goes to your ineffective assistance of counsel that you would like us to determine on the face of this record, where perhaps we don't have the mind of the
There were a number of
defense
problems.
lawyer here.
There were a number of problems about the defense that, to the extent I'm able to, I would like to not devote time to this morning. Such is the nature and the depth of the prosecutorial misconduct in this case. Because, like I think, obviously, because I briefed it that way, Judge Northcutt correctly hit it right on the head. He backdoored that in redirect. Counsel on cross asked you about firearms. You know about firearms, don't you? So now let's take this complete tangent and let's talk for the first time about laser sights with a very minimal, and this goes back to your compound question originally, Judge Badalamenti, that there was some testimony. But again, if you didn't know anything about laser sights before you read this transcript, based on those two very broad, laser sights are kind of a thing, they involve lasers and firearms. I mean, there really wasn't any substance to her testimony. I think it's clear counsel was setting it up for what he was going to do in rebuttal, and it fails for this even worse in rebuttal, because if you look at the closing argument that supposedly invited that response, if you can make any sense of that argument whatsoever, you are a finer reader than I, which is, of course, a rhetorical, because you probably are a finer reader than I am, but it was gibberish. The context in which defense counsel was challenging the state's burden, and that's what he was doing. He was holding them to their burden, and the word laser did come out of his mouth, but it was nonsense, and you can't invite new argument on testimony that doesn't exist on the record off nonsense challenges to the state not having met their burden of proof.
The testimony stated that a laser sight, and this is by the FDLE firearms witness, and I'm looking at page 385 of the transcript. A laser sight is usually some sort of device that's attached to the firearm itself, and it will give a little laser light off when it's turned on, and it will just project, which should be like a target or an accuracy type. I've only seen red as that color. The jury was presented with a video where, like Judge Northcutt said, perhaps in real time it didn't show, and the jury was presented with argument that it is there, and although not cross-examined with the video itself to suggest that it was there, the FDLE expert, the jury was able to be free to accept or reject the notion that the red dot and the laser testimony didn't matter worth anything.
I obviously disagree. The reason I disagree is because you try that in your case in chief. Now let me get back to the two occurrences.
What happens if the comment would have been, it's absolutely clear that anthrax was given, and that's why it took him 10 seconds to fall to the ground, and we're going to ignore the big hole in his stomach, okay? And there was no testimony whatsoever about the existence of anthrax. Isn't that the better case here for you than something that was mentioned in the testimony?
No, Judge, and here's why. And here's why it cuts to the heart of why I am so outraged with the prosecutor's conduct in this case and why it is harmful. You don't do that in rebuttal. And I can make an example. The court's mentioned on at least one occasion there being two frames in which something red appears in the video, consistent with counsel's answer brief. I believe it's Exhibit 9. I believe that can be seen at minute 1:16 and 1:17. I don't want to look down, but generally it appears in two different locations. The answer brief doesn't point out to the court that at a minute 10, something substantially similar appears. Within about 3 feet within that parking space of the ones at 1:16 and 1:17. At 1:10,
Oh, yeah, you're right.
Oscar Crespo Rodriguez,
See that one? I have it right here.
he's not in frame. Who's in frame? The decedent and Stephen Rivera. And that would be really neat stuff to argue to the jury in closing if the state didn't ambush that theory in rebuttal. So what opportunity did defense counsel have to argue the facts and evidence? He did argue the facts and evidence.
Well, and I will tell you this is kind of, I don't remember precisely what the prosecutor said. But as I was looking at the video, and it's it's really weird in an appellate situation to be reviewing this evidence in this way, but I saw 2 points of red light, and ascribing to that what the state's theory was. The first one looked to me like when the defendant would have pulled the gun out, and then the second would have been as the defendant was running away after shooting. But those are the 2 that I had noticed. The one that you've just pointed out earlier would undermine that theory. What was causing these? If this was a laser sight, what was causing it to happen?
I don't know, Judge.
It's not answered in the record.
And I don't concede that it was a laser sight, and I threw out the words in the initial brief without citation, obviously, digital artifacts or lens flare, which really underscores my point. There was a time and place for the state to have introduced evidence of that theory so that defense counsel could have appropriately prepared and responded to it. We have no business going frame by frame.
And frankly, I just find it suspicious that the question was not asked by the prosecutor of the person. Do you know what laser sights are? Can you look at this video and see evidence of a laser sight?
Well, and as to
I
what...
wasn't asking. That's kind of troubling to me. The problem is that really you have preservation problems here, I think, on the argument.
How so, Judge?
But you have a motion for mistrial there?
No, Judge, but he did object. He objected, and as...
It was overruled?
I don't know if it was Robinson or not, but where the objection is overruled, the motion for mistrial is moot. And unlike...
I'm not so sure that's the state of the law.
Yeah, it's the state of the law.
You know, to the extent that he objected once and not to... you had 80-page closing argument here, I think, right? And he objected to one instance of the reference to the laser as overruled, and without argument as to, you know, the need for a curative instruction or something like that. We're not here to second-guess the trial judge's discretionary ruling on an abuse of discretion standard, presuming it's preserved, okay? When we had testimony, perhaps the state did stand back, okay? Perhaps it did, okay? We're confined here to say whether or not the statements that were made by the FDLE person, it was a fair comment for the prosecutor to ask the jury to make a conclusion that if they determined the red dots to be there, okay, that's something that they can consider. Is that a fair comment? You say no. And then I'm going to ask the same question to the state.
Well, and Judge, as to whether or not that single objection was sufficient, and I don't think I've ever asked this from the podium, I would love the opportunity to prepare a supplemental memorandum on that point. I know unambiguously in the 11th Circuit, if he didn't continue to object 47,000 different times and in writing and in stone and Sanskrit, that it would have been waived. But I think it was legally sufficient. I think he fulfilled his obligation. He preserved the error. I think if this court follows the reasoning and the holding in Robinson, the outcome must be the same. One does not try cases like that. It does not give the defendant an opportunity to respond to the facts not in evidence that are alleged to support conviction.
And it's your position that the whole argument that the state used no technology, nothing whatsoever, it offered nothing, and that broad argument in the defendant's closing arguments did not permit the door to be cracked open to show a piece of evidence that, or testimony, to say, well, here's one.
It's the point, Judge. They didn't present that testimony. how can it open the door to the fact that they didn't present the testimony in their case in chief that that could have been a laser sight?
Mr. Upson, you're well into your rebuttal time.
And it was only 2 minutes, Judge, so
We will be generous.
thank you.
Thank you, Mr. Upson.
May it please the court, Todd Chapman on behalf of the appellate of the state of Florida. Just want to start with a couple salient facts. First of all, we have two witnesses, Ms. Riviera and Mr. Gauthier, that put the appellant close to the victim at the time the shot was fired.
And these, and as I recall, there was, some people said they didn't see any gun or whatever, but they heard the shot.
They heard the shot, and they both identified a particular page in the record. It's a still shot that shows the appellant within arm's reach of the victim, and it shows Mr. Riviera several feet out of.
And right after that, the decedent stumbles back in the video anyway.
And then he goes forward and collapses. Yes, Your Honor. So we have two witnesses that put the appellant within arm's reach of the victim at the time of the fatal shot was fired. And then we have the testimony of the medical examiner, Dr. Falsgraf, who says that the fatal wound was a contact wound, that the gun was actually pressing against the skin of the victim. So you have those three salient facts, which I think are quite important in this case. Now, moving to issue one, the thing that I think has gone without saying, but is important, is the video is in evidence. You know, we hear this talk about, well, there's things that that are in the video that were not in evidence. The video was clearly in evidence, and each frame of that video was part of that video that was.
What bothers me, Mr. Chapman, is that you got the person who's they don't give expert testimony because it's more, have you ever seen it? Are you familiar? But this person could have given theoretically expert testimony. Yeah, that looks like a laser in the video, but they don't do that. And then they come back in rebuttal and say, jurors, you have now been educated. You are the experts, which, excuse me, it's not true. Look at those red dots. Aren't those lasers? Those are laser dots, right? And you know, so now you've got the jurors bringing an expertise to the physical evidence that they really don't have. That's troublesome.
I understand. Well, first of all, it was not clear until the defendant's trial counsel gave his closing argument what the defense was going to be. It was not clear whether or not this was not going to be a defense of, a self-defense argument.
But even so, now, granted, the prosecutor is like winging it based on what the defense argument has been. Even so, where is the evidence to back up what the jury is asked to believe about this video? I just don't see it, that it's there.
Well, I would just go back to the fact that video is in evidence, and I think
I've been looking at it.
And I appreciate that the court has taken the time to look at the video. But I don't think it's the job of the prosecutor to necessarily walk the defendant through, in a pretrial context or even in trial and say, okay, this is what this frame is, this is what, once the video is in, I think it's fair game to be used as the prosecutor sees fit. And there is the testimony of the FDLE examiner.
Whose only contribution is that they've only seen red laser sights.
And she did, as Judge Badalamente read, she did give a definition of what a laser sight is. It was a brief definition.
But didn't relate it to the video.
This is true. And of course, she was not present. She did not see, she was not an eyewitness.
But she could have looked at the video and given, theoretically, an expert opinion on what was shown on the video, correct?
It's possible. I don't know,
We don't know.
Don't know what
But
she
if
would have
she
said if
couldn't-
asked those questions.
If she couldn't, how could the jurors? You see, this is the problem. This is the problem I have. She didn't connect those two up, and then the prosecutor says to the jurors, they're connected up. You guys, you have been imparted this information, about laser sights. Look at that video. Those are laser sights. Excuse me, where's the link up there? I don't see it.
But I think once the defendant put Mr. Riviera in as the possible shooter, I think it opened the door and it also talked about, why did the state not use more technology? Why did the state not, do a further investigation? I think the door was firmly opened when the defense made that argument.
Make up a connection. That's basically what the prosecutor did in the case.
The prosecutor took the evidence that was available that had been duly admitted.
And suggested evidence that was never presented. That is, that those red dots were from a laser sight.
As the FDLE officer had defined. If I can just move to just a couple other issues. First of all, on the preservation issue, by my count, the prosecutor referenced the laser sights 3 different times. The first time, there was no objection. I believe that's on page 516 of the record. Then there was a reference to the laser sights, which drew an objection, but there was no request for a continuing objection. And then going further after that, the prosecutor cites the laser sights again, and that issue is not objected to. So we do think that there is a preservation issue on 2 of the 3 references that the state made to the laser sights.
Why don't you guide us through a harmless error analysis?
Well, I think I would go back to where I started, and that we have 2 witnesses that put the appellant next to the decedent. There are no other witnesses. There are no other parties within arm's reach of the victim, and we have unquestionably a contact wound caused by the shooter being within arm's reach and pressing.
Aside from you got the video that shows the defendant kind of doing this.
Absolutely, and that's what the 2 eyewitnesses used as their key point to say this is where the defendant was when I heard the shot. Yes, absolutely. The video is a very key piece of evidence. And just briefly, the Robinson case, which was discussed by my opposing counsel, the prosecutor clearly in that case misstated what the testimony was. The prosecutor said that the homeowner or the person, the homeowner in that case had told the defendant to leave, Mr. Robinson to leave. That was not the testimony.
No, and then I think Judge Northcote just wrote that's a wholly fabrication of what wasn't presented.
Absolutely.
You know.
And that's clearly not the case here.
Judge Northcote brilliantly.
Succinctly and brilliantly. That's right.
A great use of the term bacchanal, if I'm pronouncing that correctly, too.
Yes.
And I don't believe my opposing counsel referenced issues 2 and 3, so I will stand on my brief on those issues. If the court doesn't have any further questions, we would ask that the judgment and sentences be affirmed.
Thank you, Mr. Chapman.
Thank you.
Mr. Robson.
Thank you. Counsel reiterated some of the salient facts, and I go back to Robinson again, where the whole issue on that burglary count was whether or not he was an invitee, and where Judge Northcote acknowledged that there was evidence presented during the course of that trial that the door had been kicked in on his return. Pretty strong evidence against being an invitee, and nonetheless those prosecutorial misstatements in rebuttal were sufficient that the court found it harmful. I appreciate the word laser had been said prior, not to the extent. I think it's obvious. I think if you show a college student, a high school student, this transcript, and you ask them what was the prosecutor doing here, I think this was an ambush. I think this was a deliberate setup. And when he began in rebuttal, he or she, when the prosecutor began in rebuttal, to the jurors, take a ruler. No. No, the witness in the stand, take a ruler. And you explain to the jury why it is your testimony.
Well, and I do, it gives me a lot of concern, because if you don't know you're going to make that argument, there's no purpose in the question to the witness.
That's
That's
correct.
the problem I have.
That's correct.
And then the questions stop right there. Why?
And it was such a soft,
I have a real concern about what happened here, because if I've got that witness ahead of time and I'm showing them the video, and I ask them, well, those lasers, I would ask that question of the witness in prep.
well, the very last thing I'd like to point out, where that red artifact appears at a minute, it's not exactly a minute, 10 seconds.
That's what I've got there.
It's, if you start at a minute 10 and play, minute 10 to a minute 11. My software doesn't resolve fine enough for me to tell you the precise moment. Steven Rivera is in the frame. Oscar Crespo Rodriguez is not in the frame. And this is exactly the sort of thing that should have been a factual issue for the jury based on evidence in the case in chief. Not, hey, do red lasers exist? Are they a thing? Okay, thank you. I'll tie all that up later in rebuttal when there's nothing anyone can do about it. And I will tell the jury, when you get back there, take a ruler and do what is essentially ballistics and forensic video examination
Well, and frankly, you know, I grew up with guns, got a gun. I've never dealt with a laser sight. So I have no idea what makes them come on and off. Do you turn them on and they stay on? Something causes it to come on and go off? Because there are now, you pointed out, 3 places where that red dot appears, but it is not constant and it's not moving around. It's just boom, boom, it's gone. So something turning this laser on and off, something an expert witness might have talked about.
Should have been testimony, and that's the crux of my point. Should have been testimony.
And it is clear here, the sole objection was on the basis that it was, there were facts not in evidence by an expert.
I didn't read that into the...
Exact objection and no other objection, is that correct?
Well, I read it as being the 2 separate, which I don't know...
Facts not in evidence.
And would require expert testimony not presented.
And there was no attempt at cross-examination or an objection as to relevance or anything
During the-
when the FDLE person,
No objection during the redirect.
nothing.
That's correct.
Okay, thank you.
If the court would entertain a supplemental memorandum, would you prefer I present that later this
We'll let you know if you need it.
Thank you.
Thank you very much.